Live.
Good evening, everyone. My name is Sydney Dominguez of George Mason University's Federalist Society chapter, and I'll be your host for tonight's FEDSOC Study Break on Natural Law. We'd love to hear from you to join in today on today's discussion, so if you have any questions, please feel free to use the question and answer function in your Zoom window. Now, without further ado, I'm pleased to introduce Professor Lee Strang of the University of Toledo College of Law. Professor Strang joined the faculty at University of Toledo in 2008 and was named the John W. Stoppler Professor of Law and Values in 2015. A graduate of the University of Iowa, Professor Strang also holds an LLM degree from Harvard Law School. In 2015, Professor Strang was a visiting scholar at the Georgetown Center for the Constitution, and in 2016, he was appointed to the Ohio Advisory Committee of the United States Commission on Civil Rights. In 2017, Professor Strang was awarded the University of Toledo's Outstanding Faculty Research and Scholarship Award. And in 2018 to 2019, Professor Strang was a visiting fellow at Princeton's James Madison program. In 2021, Professor Strang was awarded the University of Toledo's Inclusive Excellence Award and the University of Toledo's Creative and Scholarly Activity Award. Prior to teaching, Professor Strang clerked for Judge Alice Batchelder of the United States Court of Appeals for the Sixth Circuit and was an associate for Jenner and Block in Chicago, where he practiced in general and appellate litigation. A prolific scholar, Professor Strang has published dozens of articles in the fields of constitutional law and interpretation, property law, and religion and the First Amendment. His most recent book, Originalism's Promise, a natural law account of the American Constitution, is the first natural law justification for originalism. Among other scholarly projects, he is currently editing the third edition of his unique multi-volume modular casebook, Federal Constitutional Law, and is currently writing a book on the history of Catholic legal education. Professor Strang engages in debates at law schools across the country on originalism, natural law, religious liberty, and other subjects. Professor Strang, the floor is yours.
Thanks so much, Sydney. Good evening, everybody, and thank you to the Federalist Society for hosting us this evening. It's a great conversation. This is a wonderful series to provide an opportunity for students to ask questions that maybe they don't get answered in law schools. And I'm delighted to speak with everybody tonight about the fascinating topic of natural law. It's a fun topic, it's an important topic, but one that's often misunderstood and one that's rarely covered in law schools, and if it is, often not fairly. I'm looking forward to answering your questions this evening, and I've got lots of suggestions on books that you could read for further information. Let me give you a little bit of background about how I ended up here talking about natural law. I came to the topic of natural law in two complementary routes. The first route was, I'm an avid reader of history, and I noticed as a younger person that really smart people throughout Western history kept referring to something called natural law. And they seemed to think it was something that was real, and they seemed to think that it was really important to know about it. The second a complementary reason is my religious tradition uses natural law to evaluate human conduct, how humans as individuals, how human communities, how human legal systems operate. And so both of those had pushed me towards learning more about natural law. But unfortunately, when I was in law school, and this is probably most of your experiences, there was only one course that directly addressed the topic, and that was jurisprudence. But even there, it was only as a kind of part of the larger course. And depending on who taught it, it might not even be a fair representation. So like many of you probably, I started reading earnestly about natural law sometime in law school. And as Sydney identified, the research I did most recently culminated in my book, which provides the first book-length natural law account of an originalist interpretation of the US Constitution. So that's a long way of saying that if you're new to the topic of natural law, you're not alone, that all of us are new at different points in our time. Let me share a couple of anecdotes about my own law school experiences that are probably unusual, at least I think they are from what I've heard. I had the opportunity to marry my lovely and talented wife, Elizabeth, the summer before we started law school. We didn't have a lot of money, we were newlyweds. We ate a lot of hamburger helper, and the reason for that is not because we thought it was tasted super good, but my father-in-law is a farmer from Iowa, and he gave us free ground beef. So we ate a lot of hamburger helper. I had ham and cheese sandwiches during lunch in the cafeteria. We even had our first child after my first year in law school during my first summer. So we had a really full life in law school. It was a really wonderful time in so many ways, but it wasn't so full that I didn't have the time to be a nerd or a political junkie still in law school. So after my first semester exams, I know how many of you probably felt like, wow, that was quite the experience. And when I was in law school, it was the first day that C-SPAN was carrying the coverage for the House impeachment proceedings for President William Clinton. So I spent the next day just watching all those impeachment proceedings. This topic is a wonderful topic, and I'm glad we're going to spend a half an hour talking about it together this evening. To get us started, let me identify a few situating remarks. First, natural law is a vast topic, and we'll only be able to touch on the high points this evening. For example, the concept of the common good is essential to most conceptions of the natural law tradition, and there's significant consensus on what it means, but there's also continued disagreement on its exact boundaries, and we won't get into the weeds of that disagreement. Second, the natural law tradition is a big tent with lots of different views about what natural law is and who is in and who's not in the tradition. And I'll work hard to be ecumenical, but be aware that I do come from a particular perspective within the tradition, what's often called the Thomistic natural law aspect of the tradition, named after St. Thomas Aquinas. So those are my initial remarks, Sydney. So let's get to the questions.
Thank you, Professor. If you could, for our viewers who are totally unfamiliar with what natural law is, could you give a really quick description of some of the major points that go into the understanding of what natural law is?
Yeah. So at its most fundamental, natural law is the idea. It's an approach to ethics, so human actions, and it's an approach to law, and I can talk about both of those separately, that says that there are non-human created norms, rules, laws that guide human conduct, including the conduct of human communities. These natural laws tell us what human actions are reasonable and therefore good, what human actions are unreasonable and therefore bad. So just to take one example, I teach property law, that we typically think, we as humans, we as Americans, we as Westerners, that one should not take another person's private property. But I think if you've had property law, you know that unless you have a sound reason to take somebody else's private property. So if you've covered property and covered the doctrine of necessity, you know that our legal system recognizes that there are some situations where even some lower level natural law norms, like respecting private property, aren't exceptionless, that they do have some exceptions for especially sound reasons. Let me just talk briefly about, well, okay, that's pretty abstract. How does one evaluate in one's own life or in one's community's life how to identify good from poor human actions? And I'm just going to give you an outline of how to go about that. And you can think of there being two separate stages to the evaluation of how humans should act. So one is the directedness of our actions, that we as human beings act towards things, towards good things. We call them basic human goods. One example would be knowledge. So you are law students, and one of the things that law students do is that they're in law school libraries, at least pre-COVID, law school libraries reading law books. You're learning law. Now, you probably have some instrumental reasons why you're doing that. I need to take this class to graduate law school, to take the bar, to get a job, to get money, right? So that's an instrumental reason. But for many of you, including myself, you also study law because you find it intrinsically interesting, intrinsically valuable. It makes you a better person that you have this knowledge, this basic human good of knowledge. So the first part is thinking about the directedness. And so we humans, we aim towards certain goals like knowledge. Friendship is another common example. And I think for those of you who are parents, I'm a parent, if you think about what it is that you want for a young human being, a young person, that what parents want for their children is that to have a flourishing life where the young children embrace and have access to the goods that make life worth living. And so this is what we call a eudaimonistic conception of natural law, that the goal of natural law is to identify and guide us towards a full, flourishing, happy human life. And then the second aspect of natural law are the principles of morality that guide us in the choices of how we pursue these different basic human goods. So for example, one of the principles of morality that scholars in the natural law tradition have identified over the centuries, and one that I think probably all of us agree with, is that we should keep our promises. That's a lower level specification of higher level principles of morality. And Sydney, I'm happy to talk about how the natural law applies to the legal system, but I'll give that summary briefly. I guess I have one more thing to say. And there's also something called virtue ethics. So virtue ethics is a complementary aspect of the natural law tradition. It looks at not the rules that guide us, but the types of character that we have that help us both identify what the goods are that make life worth living, and then help us most effectively and judiciously pursue those basic human goods. And so one of the standard virtues, of course, is temperance. And if you think of an intemperate person, somebody maybe who struggles with alcoholism, that they are blinded to what's truly good, maybe friendship with their family members, and they also are blinded about how to pursue those basic human goods. So virtue ethics is a complementary component, at least in my understanding, of the natural law tradition. Sydney?
Thank you. So just moving on to our next question. Now that we've talked about what natural law is, I want to talk a little bit about what natural law isn't. So I
Okay.
know that some people have, said that natural law is just legal positivism, or they found some tension between those two topics. Could you talk a little bit about that?
Sure. In the Anglo-American world, where we are studying to be lawyers or are lawyers, there are two basic perspectives, at least in the 20th century and now the 21st century, on what law is. And one goes by the name conventionally of legal positivism, and one goes by the name conventionally of natural law. And I want to make two moves, actually. So the first move is to say that there's, I think, a conventional view of those two camps that actually isn't the state of the art today. So the conventional view is that legal positivists say that there's something called law and it has no relationship to morality. And there's a grain of truth in that, but then it seems to portray folks who argue for legal positivism as if morality is irrelevant to the enterprise of law legal systems. And that's not their position. And then the other aspect of the conventional view, which I think is mistaken, is that the natural law tradition says that law is morality, that they're coterminous, that if a law isn't fully just, then it's not a law, and it's not a law in the legal system. And there's actually kind of an interesting history that's tied to a phrase that St. Augustine, back around 400 AD, had identified. So St. Augustine of Hippo had said famously that an unjust law is not a law at all. And that's meant to stand for the proposition that people who are natural lawyers don't think that unjust laws are laws. I don't think that's the state of the art anymore. So today, Sydney, that a legal positivist is somebody who says it's a narrow claim. It's the claim that says that when one is trying to identify law, law is an analytically distinct and separate phenomenon from morality, that they're not the same thing, and that law is a product of social fact, like legislatures or judges or other artifacts of human life. And so there's a positiveness to law in legal systems. That's the core insight of legal positivism. And I think that's the state of the art. And there's different versions of it, which we could talk about. There's inclusive legal positivism, which has mechanisms for including morality. And then there's exclusive legal positivism. On the natural law account, I think the best work has been done over the last 40 years by John Finnis, a scholar at Oxford and Notre Dame for his career. And what I'm going to say now is really a statement or summary of some very sophisticated work that Professor Finnis has done. And what Professor Finnis has argued is that in the natural law tradition, natural lawyers can say the same thing can and do say the same thing that legal positivists say, which is that when you look at a legal system, how do you identify the laws in that legal system? Well, you look at the social facts. Has a legislature, is there a thing called a legislature? Does the legislature put out statutes? And are those statutes intrasystemically, so within the legal system, are they valid? And so there's a separate question about whether inside of a legal system, whether there is a phenomenon of a particular posited law. And if you think about it from the natural law perspective, the facticity of posited law is actually super duper important, because one of the ways to think about law, positive law, is as a technique or a tool that human communities have developed so that they can live together in peace. And the facticity of it is the way that we as a community identify what the law is and thereby live together in peace as opposed to having disagreements. But here's where the things get different. In the natural law tradition, that's not enough to say that there is such a thing called law, that it does allow humans to secure the common good of a community. That in the natural law tradition, we can distinguish between law in its fullest sense and deformed or marginal views of law. So if you've ever had this view in studying law, in whatever class it might be, you might be able to say to yourself, that's a law I'm in Ohio. That's a law in Ohio. I recognize that it was passed by the legislature, but that's unjust. That it leads to either an abuse of the common good, it leads to an abuse of the human persons in the state of Ohio. And so what you're saying, if you say that, if you have that judgment about a law, you're saying two things. It's valid in that legal system, but it's actually a deformed example of the phenomenon of law. It's not the fullest example. So you can have an unjust law, is the point, identify it as an unjust law, and then you can have different response to that. So So what you might say is that, hey, let's eliminate that unjust law. Or you might say, in some really grievous situations, you might say, we're not going to follow that unjust law, right? That's the civil rights movement. That's Martin Luther King Jr.'s letter from Birmingham jail. And there's other ways as well in which natural lawyers can respond to that. But I think there's one last point I want to make, Sydney, quickly. And that is, so what I think is the real competitive advantage of natural lawyers? It's two things. One, I just said, which is that it allows us to say, this is a law that's valid in the system, but there's something wrong with it. And number two, it answers the fundamental question of why do we have a legal system? Why is it that people in that legal system ought to follow the laws in that legal system? And because it tries to say that the laws in the legal system, if they're functioning well, secure the common good of the community, and that common good is benefiting each member of that community so that he or she can secure their own human flourishing. So the natural law tradition is able to identify the most important questions and try to provide answers to those questions. So I think that's the real value added of the natural law tradition.
Wonderful. Thank you so much. So I have questions about two natural law scholars who are obviously very popular right now. So the Federalist Society's Harvard Journal of Law and Public Policy just published a piece by Professor Adrian Vermeule, who's a proponent of common good constitutionalism. And I wanted to see your thoughts on how that interplayed with natural law as well.
Yeah, so I'm actually just finishing up Professor Vermeule's book, which is a more extended version of the article that Sydney had referenced. And so let me just say some background about common good constitutionalism. It's a really interesting phenomenon. It came on the scene in April of 2020. Professor Vermeule, Harvard law professor, a famous, influential, very sophisticated, primarily administrative law scholar, published an essay in The Atlantic arguing for what he called common good constitutionalism. And it had two basic moves. First is there's this thing called common good constitutionalism, which is valuable and good and what our legal system should be pursuing. And then there's these other two things that are defective. There's originalism, which is defective in some ways, and there's living constitutionalism, which is defective in some other ways. Let me now provide just briefly some kind of quick evaluation of common good constitutionalism. So I take common good constitutionalists to have 5 basic claims. So first, that serving the common good is an essential aspect of law in the legal system. Second, it's a key aspect of the Western legal tradition. So serving the common good is a key aspect of the Western legal tradition going back through England, through the Middle Ages, through Rome, through Greece. Third, the common good constitutionalism fits the American legal system. So it's not just the people in the old days over in Rome, it's actually our system right now. Fourth, it's consistent with the US Constitution, and officers of the United States should employ it when interpreting the Constitution. And I think all of those propositions are consistent with the natural law tradition. So just to pick one of them, the service of the common good is a central aspect of the law and legal system. That is a central aspect of the natural law tradition, that the common good is the purpose of law and legal systems. And common good is both a measure of law in a legal system and a tool that's used within the legal system and used by officers. Now, so that's the positive part. That's the part about assimilating the common good constitutionalism to within the natural law tradition. And Professor Vermeule, by the way, works very hard to make his case that the common good constitutionalism is a manifestation of what he calls the classical Western tradition, or the classical legal tradition. Okay, now let me say 2 semi-critical things. So first is, I think many of the claims by common good constitutionalists are empirical claims. So for example, one of the claims made by Professor Vermeule and other common good constitutionalists is that the Constitution's text is underdetermined. It doesn't answer a lot of legal questions. And in those areas of underdeterminacy, officers, legislative, executive, judicial, should utilize the common good and their own conception of the common good to interpret the Constitution in a way that best secures the common good of our community, our political community. Now, it's an empirical question whether and to what extent the Constitution's meaning is underdetermined. Professor Vermeule makes a very robust claim that there is significant underdeterminacy. I myself am more skeptical of that claim, and I'll give you one example. Professor Vermeule focuses on the word equality in the 14th Amendment. He focuses on lots of different parts, so this is just one example. Equality in the 14th Amendment in the Equal Protection Clause, and his claim is that that's underdetermined, and that therefore officers should use their own conceptions of the common good to give meaning and detail to equality. And I just think that that's factually not the case, that the best work out there is done by a scholar named Chris Green, who in a series of articles articulated what I think is the definitive explanation of the original meaning of the clause, and it's not underdetermined. And I think there's a second pushback I would give on common good constitutionalists, and that would be Professor Vermeule criticizes originalism for its inability to secure the common good of the community. And I think that you have a number of original scholars, myself being one of them, who have argued that originalism, in fact, is our legal system's way to secure the common good of our community. Now, it may not be as thick and robust a common good as Professor Vermeule is advocating. I think that's actually true, but I think that's just a circumstance that we in the United States live in and have lived in a relatively pluralistic country with people of differing views in good faith and reasonably so. And so that conception of the common good is going to be thinner to accommodate those different broader perspectives. But so my second pushback would be that I think originalism is actually our system's way to secure the common good. Sydney?
Well, thank you. And then I want to bring up another scholar. So this weekend, I was actually at a James Wilson Institute event with Professor Liarkis, and he talked about natural law, and he recently published an article in First Things about natural law and how that's going to affect the upcoming Dobbs case. I was wondering if you had any ideas about how natural law can play into that, into the case, into the opinion that we'll end up seeing. And do you think the justices will actually pull any natural law arguments for their determinations?
Yeah, so let me step back and just say kind of a general thing and then focus on the Dobbs case, if that's all right. So the general thing is, my view, and I think this is a core aspect of the natural law tradition, is that whether and to what degree officers in a legal system can use the natural law to judges always have to use natural law or never get to use the natural law. Instead, it's up to each legal system based on its circumstances to decide whether and to what degree officers use the natural law. My view is that at least the judicial officers in the United States very infrequently have recourse to natural law. But that would be an empirical question, right? What we'd ask is, in 1789, when the phrase judicial power was ratified, what was the public meaning of that text at that time? In my understanding is that it was the case deciding function. It was the authorization and duty of judges. This is Marbury versus Madison 101, to decide cases under the law. And you notice what's missing, not under natural law, right? That wasn't part of the equation. So that's the general thing I would say. And then applying that to the Dobbs case, there are two basic questions in the Dobbs case. One question, well, actually three questions. So one question is, does the Constitution provide, does the Constitution's original meaning provide a right to abortion? And it's pretty clear that a majority of the justices think that the answer to that is no. And they think that the answer to that is no, not based on natural law, but because the Due Process Clause of the 14th Amendment, either its original meaning or some other kind of precedentially informed meaning, doesn't include a right to abortion. Second question is, okay, let's say that you're a justice and you think that that Roe and Casey and other cases that identify a constitutional right to abortion are wrongly decided, then what do? That's the area of stare decisis. And there, I think there's actually significant space. This is my own view. There's significant space for justices to employ their own conceptions of natural law to decide whether to overrule, whether to affirm, whether to limit a case such as Roe and Casey. And I'm happy to talk more about that. I talk about it a lot in my book as well. But the basic point is that natural law, I think, plays a significant role in deciding how to deal with non-originalist precedent. Third question, is an unborn human being, so a person within the meaning of the 14th Amendment, is an unborn human being a constitutional person, therefore entitled to the rights of equal protection and due process? I don't think the justices are going to get to that position. That was something that Justice Blackmun addressed in Roe versus Wade. And I do think there's a definitive legal answer that the law provides. And so even there, if the justices got to it, I don't think natural law would play a role. So that's a long way of saying that I think outside the context of stare decisis, the Constitution gives us an answer to the question the questions that Dobbs is facing.
Thank you. So I'm going to move to a couple questions that we have in the chat. Matthew and Jensen both asked kind of similar questions. The two figures who I mentioned, as well as some of the people who you've mentioned as natural law thinkers, Aquinas, Professor Arcus, Professor Vermeule are all religious folks, does natural law theory necessarily rest upon having a religious belief? And if not, how is that? How is it conducive to in American society where we don't necessarily have a state religion or something like?
Yeah, yeah, that's a great question. I'm glad it was asked. And it's interesting. So let me say a couple of things. So one is that the questions that you identified, and the people that I identified, like let's say Thomas Aquinas, were religious folks. I think that's, yeah, I haven't thought about it enough to know whether that's accidental or a or some kind of a manifestation of the tradition itself, or just a manifestation that in the Western civilization, most folks for most of history have been religious of one sort or another. And I'll give you a concrete example. So Aristotle is often, although disputedly, identified as the father of the natural law tradition, at least in the West. And most people think that Aristotle believed in a deity, but certainly was not the kind of deity, or at least maybe shared some characteristics, but had significant differences to Thomas Aquinas's conception of the deity. And so, if one thinks of Aristotle as a natural law thinker, which I think most people do, although inchoate and maybe not as fully developed as later, then I think he would be a counterpoint to the position that one has to believe in maybe a conventional God in order for one to believe in natural law. And then there's a second way, I think, to get at that issue, and that is, in my description of natural law, I relied on no theological claims, no religious premises to support my description of the natural law tradition. My claim, there were twofold, right? One claim was that there are these things called basic human goods that we as human beings try to achieve: knowledge, life, friendship. And my claims and what in your own evaluation of those claims involves no relationship to what does God tell me to do or not tell me to do, or is there a God or isn't there a God. And the second aspect was trying to think about the moral norms that inform our pursuit or directedness towards those goals. Like in the one I gave was to not break promises. And again, those kind of moral norms, treat others justly, do unto others as you would have them do unto you. So the kind of golden rule, but in a non-theological sense. Those as well don't require one to believe in religious propositions to achieve that. So I'm confident that the natural law tradition both in fact had and has people who are not religious and whose premises and arguments are not religious or theological. But it is the case that many people who follow the natural law tradition, articulate the natural law tradition, are religious or have different religious backgrounds. And I'll say that's one last thing I would say is that when you think of the natural law tradition in the West, it includes folks both who are non-religious, folks who are Christian, and folks who are Jewish. But now with significant immigration from Muslim countries, there are Muslim proponents of the natural law tradition as well. And so if it's religious, or at least demographically religious, it's religious in the sense that basically it seems like any human beings who have religious inclinations can follow the natural law tradition. So those would be the responses I would say to that really important question.
Wonderful, thank you. I see we're coming up close to our time, so I have a couple more questions.
Sure.
John asks, if you had to imagine you're making a course on natural law, what scholars, what writers would you include in your syllabus?
Yeah, that's a great question. And I think it would depend on who my audience is and what my goal with the course, because I can imagine a course on natural law being structured in different ways. And so here's the people that I would say that I think are important to read, and they're in kind of a chronological order. So thinking pre-modern, I would have Plato, I would have especially the Republic, I would have Aristotle, the Nicomachean Ethics and the Politics. As a secondary source, Richard Kraut's book, Aristotle, I think is a really great resource on Aristotle. St. Thomas Aquinas, his Summa Theologica. He has some other writings, but I think that's the main one that people go to. From the modern natural law tradition, and again, this is representing my own perspective, so feel free to take it what it's worth. I think anything written by John Finnis is just extraordinary. And there's a recent collection published by Oxford in I think 4 or 5 volumes that collects most of his published works. Get that and you read that and you'll continually have kind of eureka moments. Robert George at Princeton has a number of books on natural law. Jacques Maritain was a prominent early to mid 20th century natural law proponent. He was a Frenchman. Mark Murphy at Georgetown has a number of works. In the philosophy department, he's a number of works, Natural Law and Jurisprudence and Politics. If you're looking to learn more about virtue ethics, which I mentioned in passing, Rosalind Hursthouse is somebody whose book on virtue, I think is a good introduction to that. There's also there's a couple of folks in the legal academy that are maybe hard to identify. They're maybe like on the margins of the natural law tradition. So Ronald Dworkin's work, he passed away about 10 years ago or so, is very influential, very thoughtful. And I think his best book is called Law's Empire, or actually there's an earlier one, Taking Rights Seriously. I think that's actually his best explanation of that position. Lon Fuller, in the mid-20th century, Harvard Law School, The Morality of Law is a classic as well. And then, of course, there's lots of criticisms in the natural law tradition, I would think reading, and so which I would want to include in my syllabus, of course. And so I think H.L.A. Hart, The Concept of Law, Joseph Raz, The Concept of a Legal System, Scott Shapiro, Legality, all of them are responding in what they perceive, I think inaccurately actually, but what they perceive as to the natural law tradition. So that would be my off-the-cuff response. And just one side note, if people wanted to send me an email, because I know we're going to run out of time, send me an email with questions. I'm happy to respond to those questions as well.
That's wonderful. Professor, one last question. Could you give us a preview of your upcoming book that you're writing right now?
The one on the history of Catholic legal education? It's actually, thank you for that question, Sydney. It's there's an interesting way in which our conversation tonight, natural law, plays a tremendous role in the history of Catholic legal education in the US. So many of you are in non-religious schools, public or private. Some of you, statistically, about a third or 25% of you will be in Catholic law schools. And you might say to yourself, just sitting back, and you might think, why would a religious tradition start law schools, right? There's lots of things you expect religious traditions to do, soup kitchens, right? Maybe running hospitals, but law schools? And there's a really interesting story. Notre Dame's is the oldest, Georgetown is second, that's tied up to the Catholic natural law tradition from the late 19th, early 20th century, where the Catholic Church in the United States saw that there was there was a need for future lawyers in the United States to be formed in that tradition. They didn't think that that lawyers were being formed, let's say at Harvard and other schools, in that tradition. So let's start our own law schools that will include as a component, so you'll study easements, but you also study natural law, as a component, the natural law tradition. And that actually partially defined how Catholic legal education was up until, around 1960. And just give you one example, every school that we've been able to come across used had a course on jurisprudence that everybody had to take. And it was effectively a summary of what I was talking about this evening. And then the rest of the story is that in the 1960s, 1970s, a number of different pressures came on Catholic legal education. And so they largely abandoned their commitment to the teaching of natural law, to the articulation of natural law. And that's where mostly, for good or ill, that's where things stand today. So the history is one that's bound up. The history of Catholic legal education in the US is bound up with really important issues of jurisprudence and legal philosophy.
Wonderful. Thank you so much for joining us, Professor Strang. We really appreciate you taking the time out to speak with us.
Sure, it was my pleasure, Sydney. Thank you for hosting us tonight.
Thank you. And thank you all of you for joining us tonight. And we hope to see you next week at our next FEDSOC study break. Have a good night.
Have a good night.